I'm Autumn Johnson. As Ann said, I'm the executive director of AriSEIA, which is the state's solar storage and electrification trade association. We advocate for pro-renewables policies at every level of government in the state of Arizona. And I don't have a formal presentation today. What I really want to do is two things. So the first part of the conversation is just to talk about what bills are energy related that are still alive at the legislature and kind of what do they do. This is going to be advocacy light in that I am going to tell you like my concerns or position on them, but it's really more just an information sharing thing. I'm not trying to lobby you. I realize that most of you or none of you probably are the government affairs folks for your cities or counties. So I want you to know about what's going on. And then we're going to transition into talking about the one bill that we're actually supporting and running this session, which is on solar app, which is the topic that we presented in December. And so I'd really like people to just jump in as you have questions. It's really meant to be more of a discussion. I literally have a spreadsheet up where I'm just running through the bills. And so don't feel like you're interrupting or it's a bad place to stop or something along those lines. So AriSEIA generally was tracking 23 bills this session. And people always say to me, it feels like there's a lot more energy bills this session. And that's not really the case. So my spreadsheet reflects that in 24, we were tracking 20. In 2023, it was 24. In 2022, it was 27. So it's always in the 20s ish related to the different bills that the legislature brings up. I think what's interesting, and they're almost always negative on renewables. I guess I should say that my spreadsheet is only bills that were likely to move from the beginning. So in the Arizona legislature, pretty much if you're not in the majority party, your bill will never see the light of day, essentially, because the committee chairs have complete discretion over what bills do or do not actually get heard in committee. And so my spreadsheet and the ones that I'm talking about now are all Republican bills. Very, very occasionally a Democrat bill can squeak through, but I think it's like a handful a year. And so haven't seen any of those energy related in the last few years. So these are all Republican bills. They are overwhelmingly things that are negative on energy. And I should say that I did lose the call a couple minutes ago. So if I start breaking up or people can't hear me, please just let me know and I'll switch to my phone. Um, and so these are mostly bills that are not good when it comes to wanting to advance clean energy or renewables for the most part. There are some exceptions. And then they are all really focused on utility scale. So what we've seen the last two sessions is that really the focus of the legislature and to some extent, what we're seeing in the cities and counties are all bills or ordinances that are targeted at prohibiting or limiting utility scale renewables development. So I'm going to run through the bills just in chronological or not chronological order, numerical order. And just for reference, if a bill starts with a 2, it's a House bill. And if a bill starts with a 1, it's a Senate bill. And so HB 2201 might be one that you all have heard about. That is the utility wildfire bill. That bill has received a lot of attention in the media, from the Corporation Commission, and on the floor. There have been numerous amendments. It did fail initially in the House. It did, and I should also say that I went through and I updated my spreadsheet last night. So all the information I'm giving you is as of last night. So if something changed on the floor today and it wasn't agendized correctly, then it would be wrong. But otherwise, they should primarily be correct. So this did, after amendment, get out of the House and is now in the Senate. It's passed out of committee and now it's just waiting to move forward in the Senate. It passed out of the Senate Finance Committee on March 24th. This bill is interesting and I think has been confrontational or controversial, not because anybody is supportive of wildfires or anybody doesn't think that wildfire mitigation is a good idea. The fight has really been over the reduction in liability for the utilities. So it is my understanding that the utilities will not be doing anything new as a result of this litigation or this legislation. What they've been telling me is that this is just basically kind of codifying what they already do in exchange for a reduction in liability. And there's been a really big fight over how far the reduction in liability goes. what kind of damages can be included, whether or not you could do class action lawsuits, whether or not it has to be reckless versus negligent, what the standard is for review, whether it's clear and convincing or it's preponderance of the evidence. All of those kinds of things are really in the mix. Interestingly, it has the trial attorneys, most of the NGO advocates, and the insurance companies all in opposition to the utilities and sort of more utility aligned groups like the chambers and those kinds of things. There was someone that spoke in committee from one of the communities that spoke in favor of the bill, and one of the firefighter groups has also spoken in favor, which is interesting. And so that bill is still moving. That's probably one of the most controversial energy bills that's being heard this session. That's not directly solar related. So AriSEIA itself has not signed in, taking a position on that. Though I myself, as Autumn, have a lot of concerns about the public policy itself and the potential ramifications. If you have questions about bills, you should just raise your hand. Otherwise, I'm gonna keep moving, but I don't want to miss anybody if you have questions about a bill at the time. There has been a lot of focus on wind this session. Obviously, President Trump has made a number of statements and had executive orders that are not supportive of wind or indicate a lack of support for wind. There is a project in Apache County called Lava Run that has created a lot of local opposition. There's a Facebook page and these kinds of things. A bill was run, it was originally HB 2223, that would have essentially, in our view, prohibited wind development in this state. It had so many poison pills in it. I mean, there were, I think there was at one point, there's a 6-mile buffer zone. You have to get approval from every city within 25 miles of a project. There was language in there that allowed a referendum on any decisions made by counties that had already approved projects. You could do a protest if you're within like 12 miles of a project, if it's on state trust land. And the counties actually County Supervisors Association did come out in opposition to that bill. That bill did fail on the floor. And it got amended to make it more extreme, and then it got amended to make it less extreme. And it still has not made it out of its original chamber, which is the House. But now it's changed numbers and is now SB 1150. We're still in opposition to it, but they have modified it so that it no longer applies to projects on private property. It just applies to projects that are on public lands. So it would directly kind of prohibit a project like Lava Run and any project that is on both private and public lands would have a problem. I'm going to pause there if anybody has questions about that wind bill. Okay. I'm going to skip our bill. I'm going to come back to that a little bit later. There was a bill run called HB 2518, and that had specific prohibitions kind of designed to mitigate the revolving door between the ACC and the entities in which it regulates. And the Corporation Commission came out really, really strongly against it. There was kind of a public feud between some members of the legislature and some members of the Corporation Commission, all Republicans, mind you, over this bill. It has since been, amended pretty significantly, both shrinking the time period and also reducing who it applies to, whether it's staff or commissioners. And that bill is still moving. That did pass the House. And then it passed 7-0 out of committee in the Senate, and then it just passed rules yesterday. And so we are expecting that to be heard on the floor sometime. I guess I should have a little caveat to say, kind of the expectation is that things are going to slow down in the legislature as far as actually passing out on the floor as budget negotiations really ramp up and are currently underway. So we were moving at a really fast clip for a little while, where it was almost like on a minute by minute basis, what was happening with any given bill was different. And now we're expecting things to kind of slow down a little bit. But that doesn't mean that the bill is dead. It just is sort of no fault or relation to the bill substance itself. HB 2527 is a bill that we have opposed, and the ACC has also come out in opposition to it. It did pass the House along party lines and is waiting a floor vote in the Senate. This is a bill that specifically has to do with replacing existing resources. So let's say a coal plant goes offline, what are you allowed to replace it with? And it specifically prohibits replacement with renewables or batteries. And so the idea is that essentially, if you're going to close a coal plant, you have to replace it with a gas plant. And so, there's a lot of reasons that we have concerns about that. Obviously, we're renewables advocates, but I also think that there are economic arguments to be made, right? The utilities engage in all source requests for proposals, RFPs. That's how they decide what projects to build. They have a number of factors, including cost. And so the commission sort of picking winners and losers and mandating specific technologies that may or may not have been cost competitive or won an all source RFP, I think is really concerning from an economic standpoint as far as affordability of rates. And then you also have, potentially a reliability issue as well. You don't want to have too much of one type of resource. You don't want to have just gas. Arizona's energy mix is already around 85% thermal. And so we are already more than half gas. And so a situation in which you're taking coal plants offline and just adding them with more gas doesn't necessarily increase reliability. And so that's something we've been in opposition to, and that has so far been a party line vote. I don't have any reason to expect that that won't pass the legislature, and we would probably be asking for a veto on that. And then we have several bills that have died since then. The next really big controversial bill, energy related, so far this session is HB 2679. That's the utilities securitization bill. That is probably the most complex bill that we've seen. I've seen multiple staff meetings from the Corporation Commission in which it's very clear that even the experts in energy have concerns about unintended consequences, real world implications of aspects of that bill that are not fully understood. One of the big complaints of the ACC was that both that and the wildfire bill were not run by the commission before they were dropped at the legislature. The wildfire bill has since been amended so that the ACC is no longer reviewing the plans, or will be amended on the floor so that it's no longer reviewing the plans, but securitization still directly does impact the ACC. And that was a bill that they had sent a letter to the legislature, also with a lot of concerns, arguing for one, that it was unconstitutional. That bill passed also out of committee 431 on the Natural Resource Committee in the Senate recently. It passed out of rules just on Monday. And that is a bill that I personally and AriSEIA have a lot of concerns about, I think for three primary reasons. So I think generally we're, much like with wildfire mitigation, we like the concept, right? We agree that we should be taking steps to reduce wildfire. We agree that securitization as a concept, which means it's kind of like a refi, essentially, of a plant that becomes stranded or no longer economic. You essentially securitize the asset by selling bonds. You no longer collect a return on that asset, but you are recovering costs from the asset itself. We agree with the concept. I mean, if you hear the utilities sell the bill, what they tell people is, and I've heard them give the pitch to other trade associations and whatnot in argument for support, is that the idea is that they would securitize old coal plants and then be able to invest in clean energy moving forward in an energy transition. And we obviously are very supportive of that concept and completely agree with that direction. But that's not what the bill actually requires and what the bill does. And so there are consumer protection concerns with the bill. My three primary concerns with that bill all have to do with whether or not it actually accomplishes the goal that I just articulated, right? And so one of the problems is there's no sunset provision in it. And so there is no limitation like, hey, you can use this tool for plants that were built before this time or are built within this amount of time of this legislation passing. There's none of that. And so as the bill is drafted now, they could securitize pretty much anything at any point for any reason. And so they could build a bunch of gas plants in 2030 that maybe are unwise decisions. And we know in 2030 are unwise decisions, knowing that they're going to be able to securitize them in 5, 8, 10 years or whatever. And so one of the big sticking points is that it really should be for assets that came online before a certain point in time. I don't know what that point in time necessarily where they would land on that, but it should be for old assets. That's the whole point. One of the other big things is it doesn't require the plants to retire. And so they could very well securitize something like Four Corners coal plant in New Mexico, which is currently slated to go offline in 2031. That was a big focus of their clean energy goals. They could sell that to someone else, securitize any aspect of the sale that was not, potentially lucrative or profitable for them. The plant continues to run. APS doesn't have a stranded asset, and everyone's happy except for, the environment, and folks that are concerned about carbon emissions. And so to me, the retirement of the coal plant is the point, not who owns the coal plant. And so I feel very strongly that retirement should be a requirement to be able to securitize an asset. And then the last kind of really big thing along these lines is they are allowed to securitize under the current version of the bill all of volatile fuel prices that are associated, with any kind of event or any kind of asset. And the reason why solar and wind are economic and can compete on price is because they basically have no O&M, right? There are no fuel inputs as they go in. If there's a big storm or there's a big spike in gas prices, that make gas less competitive, that doesn't apply to solar and wind, and they kind of keep on trucking. If you're allowed to just securitize basically the volatile fuel costs, it really erodes the entire value proposition of moving to clean energy. And so what I fear is that a bill that's being sold as a way to close dirty plants and move to clean might actually just be a tool to keep dirty plants online longer and more economically. And so AriSEIA has come out in opposition to that. I don't know that any of the, I haven't looked recently to see if any cities or counties have weighed in on that, but to the extent that a transition away from coal is a priority for you, that's probably a bill to be looking at. I don't see any questions, so maybe this is not of interest to people. I don't know, but I'll keep going. HB 2696 is one that, has not been getting a lot of sort of chatter, but it's one of these sort of just anti-China kind of bills. And the problem is that there's not a lot of concern for the ramifications of the supply chain when you start kind of just prohibiting things from certain countries. And so this has specifically to do with a prohibition on critical infrastructure that comes from China. And obviously, and energy is actually defined as part of critical infrastructure. There are a lot of supply chains related to renewables that still have a connection to China. And so there's a real concern there about how it would impact the renewables supply chain, as well as the impact on both cost and reliability. I don't actually even know if the state can single-handedly prohibit international commerce, but certainly, that is something else to be considered. Lots of things can pass the legislature, though, without being legal. So that one is, I have a note that is currently awaiting rules. Okay, I'm going to move on to HB 2774. This is a bill that the utilities have signed in support of. This is a bill related to small modular reactors. And so this bill does two things. One is it allows big industrial and commercial facilities to, and Clark, sorry, I'm going to finish this thought and then I'll go read your question. It's hard to read and talk at the same time. It allows large industrial facilities to co-locate small modular reactors, sort of as a behind the meter technology. And, kind of our concern on that would be like, why limit it to small modular reactors? We would love for renewables to also be able to be co-located with large industrial customers and to help offset that generation. We would be happy to do that. And then the other thing is, and I think the more concerning thing just from a policy perspective is it allows, if a utility wants to replace an existing thermal plant with SMRs, it allows them to do so without any environmental review. So you would not have to get a certificate of environmental compatibility to transition a plant from, say, a gas plant to a plant that's using small modular nuclear reactors, which I'm actually, I would consider myself fairly pro-nuclear, but I do think an environmental review is kind of common sense when it comes to nuclear plants. And so that would be the concern with that. Though the Technology Council, the utilities, and some others have come out in support of that. That has passed out of the Senate and is awaiting a floor vote in the opposite chamber. Or, I'm sorry, it passed out of the House. It passed out of Senate Natural Resources on March 11th, and it's awaiting a floor vote in the Senate. HB 2788 is another Olson bill, who's a former commissioner, that has to do with utility resource planning. This is kind of a sleeper bill. Almost no one's really been working this bill. What it essentially would do is codify the existing resource planning rules of the commission. And, we have not come out really hot in opposition to this one, but I think it's generally a bad idea for two reasons. One is that the existing IRP rules aren't that good. We've been talking about updating them for probably 5 years, and there has been an open docket at the ACC for at least 2 or 3 years to update those rules. And so I think passing legislation to codify rules we all know are outdated and need to be updated is probably not the best way to go about modifying or innovating as far as standards go for resource planning. And the other problem is this is a free enterprise club bill, which is a pretty far right-leaning organization. And while it is mostly the AP or the ACC's IRP rules, they kind of just insert a couple of little extras that are really not favorable generally to renewable energy. And so there are just a little bit like some of the tests and things for what is or is not cost effective and that kind of thing are a little bit extreme. And so that's definitely a bill that we have concern about and probably would ask for a veto on should it pass. It is also awaiting a floor vote. Now, the next, I did want to mention that SB 1119 did pass. That was a bill that was intended to limit what the Residential Utility Consumers Office, RUCO, is able to do as far as advocating for customers, such as solar customers, like they did in the grid access charge fight. That bill was vetoed by the governor this week. And so that one did pass and was vetoed. And that was not even a party line passage, but the governor signed that anyway. Sort of the common wisdom is that if it's party line, it's going to be easier to get it vetoed, but if some Ds vote for it, then maybe not. And so that was not found to be correct in that case. There aren't that many Senate bills that are still kind of alive and kicking as far as energy goes. I think the next closest one to passing out and needing to request a veto on is SB 1309. SB 1309 is a little bit like HB 2527 that I mentioned before, that really has to do with when you're retiring an existing asset, what do you replace it with? And it originally had language that we thought was pretty clear that was intended to make sure that renewables cannot be used as a replacement resource for aging thermal. There was an amendment that was supported by the Corporation Commission that did modify and take out the most problematic language. But the problem is right now that it says that you basically can replace like a coal plant that retires with reliable generation. But reliable is not a defined term, and we know for a fact that a number of folks in public meetings and sometimes policymakers will try to argue that if your resource is intermittent, is therefore not reliable. That's not a technologically sound argument, but the word reliable is so vague that depending on who the commissioners are that are reviewing, the adherence to that statute, there's a concern that that renewables would be completely excluded. And so that is something that we do plan to ask for the governor to veto. That is a bill that the ACC has also opposed. There's only two more left on here. So SB 1501 is not a bill that we have participated in, but I just wanted to flag it for you. It originally had a lot or some amount of enthusiasm because there was some competition language in the legislative intent session. That was removed based on utility advocacy. And so what remains has to do with grid security reporting by utilities to the ACC. And so that's not, an area that's particularly active for us. But I know there's folks on the call that are more intimately involved with that bill. That has passed both chambers, but has to go back to the Senate for another vote because it was modified in the opposite chamber. And then the last one that is on this list that does have great significance for us is called SB 1538. This appears to be a very simple bill. It basically says, hey, if you're going to build any kind of generation, then you should have to go through the Certificate of Environmental Compatibility process, CEC. And why is that a big deal? Well, that's a big deal for a couple of reasons. So when the CEC statute as it currently applies only applies to thermal and hydroelectric resources. So right now, if you're going to build a solar project or a wind project, you would go through the CEC process if you have a transmission line that's a mile or greater, but you would not go through the CEC process for the project itself. And so the argument in the legislature has been, hey, this is about parity. Like renewables should go through the same process as everybody else. And I think that that makes sense from an intellectual standpoint. Unfortunately, that's not the practical reality. So this bill actually would not create parity for a number of reasons. One, you've got a bill running in parallel that would remove the CEC process for new nuclear. The Corporation Commission has already determined that you don't need a CEC for new gas if the individual turbines themselves are under a certain threshold. And so really what you would be left with is, if you want to build a new coal plant, which nobody is, a new hydroelectric plant, which nobody is, or renewables, you have to go through the CEC process. And so that's really problematic. The other problem is that it is on top of all of the ordinance issues that we're seeing at the local jurisdiction. So right now we have a spreadsheet that's tracking the number of ordinances moving at the city and county level that pertain to utility scale renewables. Some of them are outright bans. Some of them are kind of de facto bans in how restrictive the ordinances are. And so you have the situation in which we're having a really hard time in some jurisdictions getting any projects through. And then you would have that compounded with a state level review. They also then went and amended this bill to move it from 100 megawatts to 200 megawatts. And I think that that is specifically addressing the gas issue should that disclaimer of jurisdiction fail on in court. And so I'm going to pause there. I'm going to look at the questions in the chat. And if people want to raise their hand and ask any questions, that would be great. And then I'll move on to talking about the one pro solar bill that we are running. So we met back in December with you all, and I had some friends with me at the time who had more technical expertise in actual permitting and installation of residential rooftop solar. And they're not here with me now. I'm flying solo, so hopefully this doesn't go off the rails. But we did end up running a bill. It was originally called 2301, and it's a bill that basically requires the use of Solar App in residential rooftop permitting. And so what is Solar App? Solar App is, well, so let me just back up to say, the bill does not name Solar App. We don't require any specific platform. There are other competitors, or sometimes jurisdictions will make their own automated permitting software related to residential rooftop solar. And so the bill does not mandate Solar App. I'm kind of using Solar App generically to mean automated permitting. But Solar App is a tool that was developed by President Trump's Department of Energy in his first term through the National Renewable Energy Laboratory. And it is basically a website that does code compliant checks in an automated fashion for hundreds of cities and jurisdictions across the country. And so if you want to install solar on Autumn Johnson's house, you would upload the plans to the Solar App website, and it would do a check of all relevant codes to make sure that the plan that you've put forward is indeed compliant. If it is compliant, then the city or the county gets a notification, and then they issue the permit based on that. And that's different than how it is in most jurisdictions now, in which it is a manual review, and you're just in the queue with everybody else, no matter what they're building. And it's about a 1 hour review per project. And so you have around 40,000 solar applications in the state, so it's 40,000 man hours to review those applications for code compliance. So this doesn't have anything to do with the utilities interconnection process, which is happening in parallel. You have the county or city who's issuing the permit with the utility who's doing the same review of the same plans for actual interconnection. And then you have inspection after those two levels. And so what's happened is that a couple of years ago, there was a bill that was passed just to make it clear that you could use this automated tool if you wanted to, but it was not a requirement. And we saw some uptake in that, but there's only a handful of cities or counties in Arizona that have utilized Solar App. So Pima County, Tucson, Phoenix, Goodyear, et cetera, are examples of ones that have. And for the most part, the ones that have are like very supportive of it. So Pima County actually signed in and came and spoke in support of the bill in committee. And so we worked with the League of Cities and Towns and the County Supervisors Association to try to come to terms with a bill that, even though it has preemption, which obviously normally local jurisdictions don't like, was sort of a win-win for everybody. And so basically it's a free tool that will reduce about 1.5 FTE for each jurisdiction, depending on how many applications you do on average, obviously. And will also get all of these projects out of your queue when you could be reviewing more complex projects like for housing and those kinds of things. And so the idea is that really it's a win for everybody and there aren't a lot of downsides to it. Gail Griffin is not a big fan of solar. It was assigned to her committee in the House, and so it was never heard. I mentioned at the top of the call that an individual chair of any committee can kind of just single-handedly decide what does or doesn't move. And so we did find a striker, which is where the number 2033 comes in to go through. I never remember what the acronym stands for, but it's called the RAGE Committee. It's like regulatory something, something government something, but it stands, it's, the short answer is RAGE, which is kind of funny. It's sort of the Doge equivalent for Arizona, Department of Government Efficiency, the Elon Musk thing. So it went through that committee and it passed 7-0 about a week and a half ago, and then it passed out of rules yesterday. Yuma and Prescott have signed in opposition recently, and so I don't know what the basis of their opposition is, but I wanted to bring this to your attention for just kind of a couple of reasons. One is, we did work really hard with the league and CSA to try to come up with language that we thought would work for everyone so we can move solar along without any additional regulatory delays, but in a way that we thought that the cities or counties, were okay with. And so there was a lot of back and forth about modifications to the bill and timeline and those kinds of things and what was or wasn't concluded and what things were or were not optional, etc. And so that's kind of where we are now. We're definitely still open to making modifications if cities or counties like Yuma or Prescott, want to convey to us what their primary concerns are. But we really do think that it's literally a win-win. And so we are hopeful that that bill is going to move forward. And it really is the only bill that is sort of pro renewables pending in the legislature right now.